the National Industrial Court sitting in Abuja has, in a landmark judgment, declared unconstitutional the long-standing policy requiring military personnel to serve a minimum of 15 years before being allowed to resign. The judgment, which was delivered on September 2nd, 2025 by Justice Emmanuel Sibilim, was filed by Lagos-based human rights lawyer Inibehe Effiong on behalf of Flight Lieutenant J.A. Akirile. The court ruled that members of the Nigerian Armed Forces cannot be compelled into what it described as a modern-day slavery under the guise of national service, affirming that military officers have the constitutional right to resign at any time. Human rights lawyer Inibehe Effiong joins us now from Lagos to consider the finer points of that landmark ruling. It's always a pleasure to have you with us.
It's a pleasure to be with you.
All right. So, how significant is this ruling by the National Industrial Court, and how binding is it?
Well, thank you for having me. Of course, the decision of the National Industrial Court is binding on all authorities and persons throughout the Federal Republic of Nigeria by virtue of Section 287 of the Constitution. The Armed Forces, which has three components, the Navy, the Air Force, and the Army, they are agencies of government, they are institutions of government, and they are bound by the Constitution. They are creations of the Constitution. They are subjected to the Constitution. They are subjected to the jurisdiction of the courts established by the Constitution. So the question of whether they will be bound doesn't even arise, because even under military regime, and this is the point that we must continue to stress, court judgment, even the military, were even sometimes more open to obeying decisions of court. So on this issue, the court has taken a position, and this has been the jurisprudence of the National Industrial Court on this issue, that, look, you cannot simply say that because someone has offered to wear the uniform to serve his country, therefore, by fire, by force, at gunpoint, that the person must continue to serve Nigeria. What the Industrial Court has done is logical, it is just, by simply resetting that, look, by virtue of Section 306 of the Constitution, which is the basis upon which I went to court on behalf of my client, every public officer or every person elected, appointed, or is selected to an office appointed or created by the Constitution or recognized by the Constitution has the right to resign at any time. And that resignation is effective upon the receipt of the letter or the correspondence communicating that person's intention to resign. So what has happened in this particular case is a very sad example of the extent of injustice, the extent of the moral depravity, the abominable repression that the institution of the Armed Forces of Nigeria, has represented, particularly on this case. This is a man, my client, who joined the Armed Forces through the NDA, the Nigerian Defense Academy. He was selected in his final year in 2013 among the best in his set. He was selected for a course in the United States to be trained as a fighter pilot. While in the US, his allowances were not paid for about 5 months. In July 2014, he was suddenly recalled back to Nigeria without any explanation, thereby truncating what was supposed to be his opportunity for career progression. As if that was not enough, the authority of the Air Force, for about a year after they recalled him from the US from its course, did not assign him to any unit. They just left him hanging. And then he remained on one course as a flight officer for about 6 years, which is supposed to ordinarily be about 4 years. He was not promoted. His classmates were promoted. And let me also mention to you that series of actions were taken and targeted at this gentleman, clearly showing that the authorities of the Air Force did not want him for reasons best known to him. So the other part of the reason why he had to insist on resigning was that his own father served Nigeria in the army. His mother just retired just a few years ago as a senior officer of the Nigerian army. So this is a man who joined the armed forces based on a family history of devotion to the Nigerian armed forces. But guess what? The Nigerian army dealt ruthlessly with his father. His father's property very close to the American embassy, Walter Carrington, where he had these boats that, that place was leased to him by the Nigerian Inland Waterways. He had done this business over the years. Some nefarious elements in uniform, including generals, out of great personal pursuit, attacked this man's business, set fire on his boat, chased his worker out. But this was somebody who served the army. Someone that the Inland Waterways had given license to do business. He had not trespassed on the property of the army, but people in the army had business interest in his business. Destroyed his business, set everything on fire. He went to court and won them. Yeah. The court ordered the army to vacate the place. The army refused. The officials of the court went to enforce the judgment. They were beaten and chased away. The army went on appeal. The appeal was lost. In 2017, I personally wrote a petition on behalf of Chief Akerele to the House of Reps. The House again passed a resolution, ordered the army to vacate the property and pay him 100 million. Again, they flattered that resolution. So while we were still fighting for Chief Akerele died without getting justice. His son, who was in the Air Force, is also being subjected to the same vicious victimization. He could no longer take it. And he said, look, I have served for almost about 10 years. I don't need pension. I'm not asking you for, and by the way, in our claims in court, we didn't ask for pension, we didn't ask for anything. We did not ask for a cover from the Air Force. We simply said, look, this man has undertaken interest in civilian endeavors. Allow him to go. They said, no. What did the Chief of Army Staff did? He issued a signal for his arrest, declared him a wall. Guess what? Guess what? Nigerians should know. In this case of Flight Lieutenant Akerele, do you know that when he applied for voluntary retirement to exit service, to disengage, he was subjected to counseling. He was interviewed. His own commander who interviewed him, who counseled him, wrote recommending that they should allow him to go, that he can no longer contribute to the service. He had become demoralized. We even exhibited before the court an official position by the Chief of Defense Staff directing that any member of the armed forces who is not motivated and no longer has interest should be allowed to go. Guess what? Despite the recommendation of his commander and the officers who counseled him, on record, this thing was before the court, the Chief of Staff still insisted that this gentleman should continue to serve. So it was on this premise that we said, look, that we cannot live in a situation where you will treat a Nigerian as if he's in a plantation, as if he's in a Nazi concentration camp. Because what they are telling us is that once you accept to wear the uniform to fight for Nigeria, to defend Nigeria, even if your life is at stake, you cannot leave. We went to court to file this action. And they came to court to say, the heading of the letter was voluntary retirement. Yeah. It was not resignation. The court said no. We even cited a case to show that in the past, the Court of Appeal has said that, look, even when you say it is voluntary retirement, what the court must look at is the content of the letter. So the court interpreted the content of the letter and said, look, this man had clearly expressed the intention that he had no longer interest to serve. And the court went further yesterday, very interestingly, to declare the provisions of what they call HTACOS, the Harmonized Terms and Conditions of Service for Personnel of the Armed Forces, that says that an officer must serve for at least 15 years before you can disengage. The court said it's unconstitutional. And that was our argument. And that is a correct position. Because if you say you must serve for 15 years before you can disengage, it becomes slave labor. It becomes slave labor. And it is not a case that Nigeria is at war, that you say you are conscripting people like we have between Russia and Ukraine now. So what is the basis for insisting that whether you like it or not, you must serve Nigeria? Meanwhile, the generals in the defense headquarters who are stealing billions meant for the welfare of soldiers, soldiers that cannot feed, soldiers that are not given uniform, soldiers that are not given arms to fight insurgents. We have seen some videos come out. Those soldiers, how many of them have been prosecuted? Very good. So you must address the welfare of officers. You cannot simply say you are not going to allow people to resign from service when you don't look at their complaints of victimization. Our soldiers are dying. Our soldiers are underpaid. Our soldiers' welfare are not catered for. This is a welcome judgment that is, again, made it clear that in this country there is still hope for justice.
Which is where I'm going. So how it took an aggrieved Flight Lieutenant Akerele to challenge the service rule due to his denial of the resignation. So what lessons can we draw on that regarding one's ability to uphold your human rights, through the courts. Is always this hopelessness and this feeling of not getting justice being done. But we're seeing something significant here. Your thoughts?
The court is still the last word of the common man. There is no alternative to judicial redress. The option available other than seeking redress in court is to resort to self-help. And that would take us back to the Stone Age, where life is short, nasty, and brutish. The survival of the fittest. We cannot live in that society. So the judiciary has its own challenges, but the judiciary is still the hope. If we did not go to court, what would have happened? They had issued 2 signals for his arrest. They were targeting him. What is his offense? He's not asking them for pension. He's not asking them for disengagement benefits. He didn't ask them for anything. Yet, they denied him promotion. They denied him his training, course allowances. They even brought him back from the course that he went for. Repeated victimization. And he now left. So we had to go to court. And the judge even used very strong language to deprecate the conduct of the Nigerian Air Force. We cannot tolerate this kind of irresponsibility. Okay. The armed forces should be the most respected institution in a country. Right. It should live above board.
Very good, Inibehe. Now, when you took up this case, did you have that confidence that Flight Lieutenant Akerile's prayer will be answered in his favor? Despite all the challenges we've been having when it comes to litigations of this kind of nature, you think?
The other interesting thing about this case? Do you know the other interesting thing? This matter was decided within a space of about 6 months.
Which, to a large extent, is...
We filed this action in 2025. And let me use this opportunity to publicly, on record, commend the President of the National Industrial Court and the judges of the National Industrial Court. The National Industrial Court today is beginning to position itself as one of the most efficient courts in Nigeria. So you can see the speed at which this matter was determined. No delay. And then the judgment is also very sound. My Lord, Honorable Justice Emmanuel Sobidili, in reading this judgment, even relied on international instruments to which Nigeria is a signatory that is against forced labor. You see the industry, the level of research put into the judgment, you commend the learned judge. So I believe that at the end of the day, Nigerians must continue to explore judicial remedy. Because what were we going to do? I was not going to carry a play card as his lawyer and say, let us go to defense headquarters and command and confront the chief of air staff. I wasn't going to do that. I've just narrated to you what they did to his father. The Nigerian army contributed to the death of Chief Akerele. And the blood of Chief Akerele could continue to be on the hands of the Nigerian army. They had a hand in his death. This was a man who fought for Nigeria. A man who wore the uniform. His wife wore the uniform, fought for Nigeria. His own son joined the Air Force. Yet, they bastardized his life, they ruined him, disobeyed court orders, disobeyed the House of Reps, as if Nigeria is a banana republic, and you are saying that despite what I've done to your father, despite what I'm now doing to you, continue to serve the Air Force. No, it was impossible. So I am using the case of Flight Lieutenant Akerele to demonstrate to Nigerians that it is possible to stand up to the powers that be in this country. It is possible to go to the court and demand redress and seek redress. And then the court will give you justice. That is what this case has demonstrated. But let me also maybe quickly say something to the Commander-in-Chief. Because at the end of the day, the armed forces is still subject to the president. Even this 15-year rule they are talking about, it used to be 10.
Okay. Some
people just sat down and say, increase it to 15. For what reason?
So, was that constitutional?
It is not. They are claiming is harmonized terms and conditions of service, a regulation that was issued.
So it doesn't have any legislative backing?
It is unconstitutional. The court has nullified that particular provision as at yesterday. The judge was very clear. I am telling the president of Nigeria, Bola Ahmed Tinubu, that if you care about legacy, you must look at our armed forces. Many officers, rank and file also, are dying in silence. If I tell you the number of soldiers that reach out to me about the injustices they are facing, you'll be amazed. So how do you expect them to be motivated to fight Boko Haram, to fight bandits, to fight the terrorists in the east that are killing people, when their own welfare is not addressed. Soldiers are among the most oppressed people in Nigeria. It is the generals that are living fat, that are taking all the money. The people that are actually doing the actual work, most of them are suffering. And nobody hears them. You know why? You cannot protest. They will say it is mutiny.
All right,
so the commander-in-chief must take the welfare of Nigerian armed forces seriously.
Which brings me to the next question, the final question, and briefly, please. The issue of a voluntary retirement instead of resignation in this case.
Yes.
How will the outcome impact other Akeriles still in the service?
Well, you see, the court demonstrated that point. Because in the interpretation of the Constitution, and this is a case, this is a principle of law that is so elementary that opposing argument cannot be taken.
Yeah.
That when you are interpreting the provisions of the Constitution, and you are faced with whether to give a word or a provision a wider or a narrower meaning, you must always lean to the wider meaning.
Okay.
So when the court had to construe what resignation means within the purview of Section 306, the court rightly held that, look, even if you use the heading voluntary retirement, once that letter that you are using to express your intention to disengage clearly shows that you no longer have interest in saving, it is interpreted as resignation, and that is correct. That is reasonable. Because what is the intention of the framers of Section 306? The armed forces is a creation of the Constitution, Section 217. So other officers who have reasons to leave, they have the right, they can resign anytime. Right. And the solution is not to say, oh, everybody is going to resign from the armed forces. The question Nigeria's armed forces, the Chief of Army Staff, Chief of Naval Staff, Chief of Air Staff, and Chief of Defense Staff must answer today is, why are officers seeking to resign? Address those concerns if you want them to remain in service. You cannot use AK-47 and point it at officers' faces and say, save Nigeria by fire, by force, without addressing grievances.
Apparently this case is a landmark case, and it's also a pace-setter.
Of course it is.
Inibehe, Effiong, lawyer, would like to thank you very much for your contributions, and more wins in that regard.
Thank you.